In the Logan Paul v. Coffeezilla defamation lawsuit, there are a bunch of issues that the judge needs to decide on. But for now, he's decided to basically freeze the whole case until the parties sit down to mediate. And that mediation is currently set to happen by November 10th, 2025. So with trial currently scheduled to start on May 4th, 2026, what does this mean for all of these unresolved issues, and what does it mean for the case overall? Will we see this case settle soon, or will we see this still march on towards trial? Either way, as someone who has litigated civil cases and been to plenty of mediations before, I myself think that this is a good thing, regardless of whether or not the parties find a settlement resolution here. Let's get into it. Okay, so as always, if you are new to this case, this lawsuit comes from statements Coffeezilla made about Logan Paul surrounding the failed NFT project Cryptozoo. Basically, Paul and his team took in a bunch of money from investors with promises of making a, quote, fun game that makes you money, unquote, and then never delivered anything to those investors. And so Coffeezilla came out with a 3-part expose on everything, and things took off from there. If you need more background in order to understand what's going on here, definitely go to the playlist that is linked in the description below. Otherwise, let's jump in. So last time we talked about this case, the judge decided in September to put this case on ice so that the parties could mediate. And then they were due to file a joint report by October 10th to basically inform the court about what kinds of efforts they've put in to negotiate towards a settlement. And this is because the judge definitely wants them to settle the case if it's at all possible, as is super common in basically any kind of civil litigation anyway. From that last order by the judge, it sounded like maybe the parties would have already gone to mediation by the time they filed this joint report, or at least maybe had a firm date in place for it, since they had a deadline of November 10th, 2025 to complete the mediation. But on October 10th, the parties filed a joint status report saying that they're still working on negotiating a date to mediate. So that means they're still going back and forth trying to find a time and place that works for everyone to get together to try to settle this thing. So because of that, on October 10th, the judge said, all right, there's no point in doing anything further. Let's push things back a little more to give you both a chance to mediate by this deadline. And so now they still have until November 10th to complete this mediation, which means that should be coming up pretty soon. So does this mean that we can expect to see a settlement between the parties pretty soon? To talk about that, let me first explain what happens at mediation for those who might be unfamiliar. But first, I have to thank this video sponsor. Privacy is a service that helps you feel safer when you shop by protecting your payments with virtual cards. And I'm really happy that they are the sponsor for today's video. Privacy helps you create virtual card numbers for purchases for a variety of uses. These can be merchant lock cards that get locked into one place, meaning if there's an attempt to use it elsewhere, it gets denied, or category lock cards so that they can be only used for certain types of purchases like dentists, pharmacies, groceries, or entertainment. Or they can be things like single-use cards that basically burn the card after you use it once. And Privacy has a free plan with no transaction fees for domestic purchases and a few paid plans with more advanced protection features. Now, there are a few things that I really personally like about Privacy. Number one is that using their product hides your real card details from websites and businesses. And that means you can stay safe from data breaches and shady sites. And if you want extra protection, you can either pause cards between purchases or set a spend limit, another key feature of these cards. Second, Privacy says that they never sell customer data. Instead, their revenue comes from merchant fees, not your information. And if you need help, their support team is made up of actual real humans. So if you want a little bit more peace of mind in your online transactions and get a $5 sign-up bonus for your first purchase through Privacy, go to privacy.com/legalbytes by following the link in the description below. Once again, that's privacy.com/legalbytes. And thanks again to Privacy for sponsoring this video. Okay, back to the video. So I think a lot of people have probably some kind of a concept of what mediation is like, but let me explain it to you, at least based off of my experiences with it. In basically any civil case, there usually are discussions throughout the litigation between the attorneys on both sides about a potential settlement of the claims. And so not every case even goes to mediation, because you might have two attorneys who are able to successfully negotiate where those settlement terms land on their own. But where the litigation is maybe a little bit more contentious, this or where the case just gets further along, you might end up going to mediation at some point. This starts with picking a mediator that both sides will agree on. Mediators are typically people who have been in the legal industry for a long time. You'll find a lot of retired judges as mediators, but they're not exclusive to them. You also might have former litigators, for example. But either way, generally speaking, you want a mediator that has some good experience in the practice area that you're litigating in. So for example, maybe for your case about a product that harmed consumers, and so you have this class action case, for example, you might want to have a mediator who did a lot of products liability litigation. Or maybe for your employment discrimination case, you want a mediator that is a former judge who presided over a lot of employment discrimination cases. The reason for that is that this mediator is going to help serve as an objective and educated third party who is going to listen to both sides and see where they can come together in the middle. Here's what this looks like. Both parties and their legal teams will go to the mediator's office. The plaintiff side will sit in one conference room and the defense will sit in another. Both sides will have prepared some kind of briefs for the mediator where they go through all the essential issues in the case, all of their best arguments, and all of the evidence that supports them. And the mediator will go back and forth between these rooms throughout the day to talk to each legal team individually about their case. There's actually a lot of sitting and waiting involved in mediation, and it typically takes all day, which is why lunch, coffee, and snacks are usually provided too. But anyway, a good mediator will usually go back and forth to each side and start asking questions to try to find the vulnerabilities in each side's case. This is at least in part so that the mediator can hold up a mirror to each legal team so that they can look at their case a little bit more objectively overall and help them to sort of figure out how much they need to move their settlement number in order to move it towards something that's a little bit more agreeable to the other side. The reason why that's helpful is because when you've been litigating a case for months or sometimes years, it can sometimes be difficult to maintain a clear view of how the case actually looks. As a litigator, you can get so focused on making your best arguments in favor of your client that you start convincing yourself that your side of the case is maybe better than it really is. So this is one of the things that's actually very beneficial about mediation, is that it's an opportunity to see what an objective and educated person thinks about your case and where your vulnerabilities are. And so the mediator will take this fresh look at both parties' strengths and weaknesses and help them figure out which side maybe should make some concessions towards a settlement agreement. Let me back up for a second and explain it this way. Let's say Logan Paul is planning to ask a jury to award him, $10 million with a verdict in his favor. He didn't list a number in the complaint, but we can figure it's probably somewhere in the millions. If the number we're talking about is $10 million, that becomes the number for a grand slam. And Logan Paul wins this case completely and everyone on the jury agrees with him 100%. So that figure isn't what we would expect to see in a settlement negotiation. That's because that's the hypothetical best case scenario for Logan Paul, but that would be the worst case scenario for Coffeezilla. So if Coffeezilla is facing the possibility of forking over $10 million to Logan Paul through a jury award at the end of trial, Paul needs to be willing to accept less than $10 million in a settlement before trial. Otherwise, Coffeezilla has almost no incentive to not keep fighting all the way through trial, other than maybe the added expense of attorney's fees, of course. That obviously is assuming Coffeezilla has any kind of gray area in possible success in his case. But anyway, what I'm getting at is that usually you'll see some kind of a sliding scale between what the plaintiff side wants, in this case that would be hypothetically $10 million, and what the defense wants, which is almost always $0. Now, paying $0 is the flip side of what I just explained, of course. That would be Coffeezilla's best case scenario at the end of trial, with the jury siding completely with him. So just like how Paul would need to go into mediation being willing to accept less than his $10 million goal, Coffeezilla would have to go into the mediation being willing to potentially pay something. That all is, of course, assuming that both parties are going into mediation and negotiating in good faith. So always a bit of an asterisk there. Okay, so if it's not $0 or $10 million, where can we expect these numbers to be going into mediation? Well, there really isn't all that easy of an answer because there are actually a bunch of factors that go into it. Maybe somewhere from 1/3 to 2/3 of that number-ish. Some of these factors can be like the various decisions that have been made by the judge in discovery fights or other things like jurisdictional factors. For example, litigating an employment civil rights case in California can be a very different experience than litigating the same case in Arkansas because the laws are likely to vary somewhat. One state might be more friendly to plaintiffs, the other might be more friendly to the defense. That can play a role here in mediation because at the end of the day, what they're really doing in mediation is trying to figure out what's probably the most likely outcome of this case if it actually does go all the way through trial, and then to see how much either side is willing to give up in order to resolve it earlier. And of course, there are also other factors outside of the specific mechanics of the litigation itself, like how this is affecting the parties personally in their relationships with their family, with their finances, with their businesses, all kinds of things like that. But arguably the biggest logical factor here is going to be the evidence that has come out in discovery. And in this particular case, at this point in the litigation, it does look like most, if not all of the discovery has already come out. There's still a motion on the docket that the judge has to rule on, and that's Coffeezilla's motion to depose some Cryptozoo investors by Zoom. But that might be the last bit of discovery in this case. And going into mediation, we can probably figure that those people are likely to talk about how they got screwed over by Cryptozoo and how they believed big claims Logan Paul made about the project. But aside from that detail, both sides at this point probably have basically all of the evidence that they're going to need at trial. So that means they can both really put their best foot forward in mediation to make their case to the mediator. And so the mediator, looking at the objective evidence, is likely to end up pushing one side or the other a little bit more towards the opposite side. So for example, if the mediator thinks that there are significant gaps in Logan Paul's evidence, because remember, he's the one with the burden of proof here, the mediator might tell his legal team, hey, you really need to bring your number down significantly. But on the other hand, if Paul has some evidence showing that he can prove every element of defamation, including actual malice, which is probably the hardest one, and there's like text messages from Coffeezilla saying like, oh, I know Logan Paul didn't scam anyone, but I don't care. I'm going to say he did it anyway just for the clicks. This is hypothetical, of course. Then the mediator is likely to go back to Coffeezilla and say, yo, if this case goes to trial and ends up with a jury verdict, you're going to get fleeced when the jury ends up coming back with a decision. And you're going to need to pay top dollar to your attorneys to go through all of that. So just accept whatever it is that Logan Paul wants to throw at you that's less than $10 million and consider yourself blessed. That obviously is hypothetical, of course. But aside from the evidence in the case, there are a couple other factors that also play a role in settlement negotiation. One of those is attorney's fees. Obviously, the sooner you resolve the lawsuit, the sooner you can stop paying lawyers to litigate the case. So both sides have to take into consideration not just the benefits of potentially winning at trial, but also the reality that winning always means paying lawyers to win that case. But there's arguably one factor that can really gum up the works more than any other when it comes to settlement negotiation, and that is emotions. I have seen too many cases go on for far too long simply because one party just digs their heels in way too much, not because they have the better case, but because they just don't want to give the other side any concessions. You can explain to them up and down why their case will not end well for them if it goes to trial, but they are just too emotional about it. And that's because sometimes people see settling a case as losing a fight or losing too much of a fight. It's like anything less than a total victory is failure to them. And having covered this case for a little while now and understanding, I think, a little bit about the parties involved, it wouldn't surprise me if Logan Paul became the stick in the mud who was unwilling to make concessions. Now, as I say that, I of course don't know what kind of evidence has been exchanged between the two sides other than what we've talked about because it's appeared publicly on the docket. But based on what we have seen, I have a hard time thinking that Paul is going to get his grand slam at the end of this case if it goes to trial. The thing I keep going back to is the fact that Coffeezilla was in continuing communication with the FBI and FCC about Logan Paul and Cryptozoo, and they investigated and followed up with Coffeezilla about the investigation. So when it comes to the very essential element of actual malice that Logan Paul needs to prove, he has to prove that Coffeezilla at the time that he made the allegedly defamatory statements, knew that what he was saying was false, or at the very least was reckless as to the falsity of those statements. But if Coffeezilla made a legitimate whistleblower claim to the FBI about Cryptozoo, and the FBI and SEC took it seriously and communicated as much back and forth with Coffeezilla, Coffeezilla can pretty easily show his sincerity later on as to his belief here. And this is, of course, on top of the fact that the FBI and SEC was already familiar with Coffeezilla's work because they had previously worked off of his whistleblower complaints in other cases that turned out to be credible. So all of that considered, I think it would be hard to convince an objective jury that Coffeezilla wasn't serious and sincere about his belief that Logan Paul had scammed the Cryptozoo investors. And based on all of that too, I think that a jury would probably find that he also was reasonable in that belief. But again, grain of salt goes with all of that because there could be evidence in this case that I haven't seen that could shift my analysis on all of that in the opposite direction. But based on what we know about Logan Paul, do you think he'd be willing to accept a lowball settlement based on a poor likelihood of winning at trial? I mean, based on the way he publicly reacted to Coffeezilla's 3-part series on Cryptozoo, to me personally, he seems like a total hothead who might have a very hard time letting go of the desire to win a total victory. And if that happens, this could end up being almost a fable-like life lesson for him. Because here's the thing. When parties to a litigation go to mediation, they don't necessarily always settle at the end of that day. Sometimes in the days or weeks after mediation, the attorneys will keep going back and forth and find a place of agreement for their clients. And sometimes after taking some time to think it over, or maybe talk with family members, the client might actually relent and decide to accept the settlement terms in agreement with the other side. But if not, at the very least, both sides will have had this opportunity to test out their arguments and their evidence in a soft kind of way with the mediator. They might walk away with new insight about a vulnerability in their case that they didn't realize they had before. And this can give them the opportunity to figure out some strategies to shore up this vulnerability before they go in front of a jury. Now, of course, I haven't exactly hidden my general sense of disdain for Logan Paul throughout my coverage of this case. But if you've been following along with me, you hopefully will have noticed that I'm also not unwilling to show when I think Paul's side has a good argument or a better argument. Personally, I'd love to see a total victory for Coffeezilla, but I also know that a total victory, meaning one that comes at the end of trial, can also be very costly for him. So at the end of the day, my hope really is that if there is a settlement that comes out of mediation in this case, that it's what both parties have decided that they can live with long term after walking away from this litigation. But those are my thoughts. What do you think? Do you have a feeling that this case might settle soon? Or do you have a feeling that one or both parties might have a hard time giving enough concessions to get to an agreement? Let us know your thoughts in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you would hit the like button. It does help us with the YouTube algorithm god. And if you're new here and you want to see more coverage of crazy cases and interesting legal topics, be sure to hit the subscribe button and the notification bell so you can find out when the next video is out there. And if you're really enjoying the content and you want to know how to best support the channel, consider becoming a member of Byte Club. You can join either through YouTube memberships or by becoming a supporter on Patreon. Links to both are in the description below. Otherwise, see you in the next one.